Thank you
This
very much.
conference will now be recorded.
I'm going to share my screen now because I have some slides that I'm going to be going through. So let's just make sure that everybody is able to see. All right, is everybody seeing my screen?
Yes.
Yes. Yes.
Okay, perfect. And it's not obstructed by the screen sharing app that I see in the right-hand side.
But we're full screen.
Okay, very good. And we're going to begin. So once again, thank you very much for inviting myself and Akshay to present today on the topic of estate planning. Just before we get into the presentation, I just want to share a bit about myself. So as Murali had stated, I am a lawyer. One of the areas of practice that I specialize in is estate planning. I've been working in this area of law for the last 5 years. I have an established practice together with my father, Graham Nichols, in Markham, Ontario. We have our office just over on Main Street, Markham. My father actually established the practice about 25 or so years ago. And as I said, I joined him about 5 years ago. Before that, I worked in a number of other law firms, but I've settled in now to focusing in on estate planning, real estate and corporate work and so forth. But for today, we're going to be focusing in on and discussing estate planning. So what we are going to cover today, first, we're going to discuss what is estate planning, what is an estate plan, and why do you need one? After that, we're going to discuss in detail what a will, last will and testament is, how it functions, why you need one, and what happens if you don't have one. And then after that, we're going to discuss what are powers of attorney, again, how they operate, why you need one, and what happens if you don't have one. And then at the end, we're just going to tie everything together. So without further ado, what is an estate plan? Now, you'll see from these slides that I have put up what I feel to be the definition of an estate plan. But before I go into that, the term estate plan is thrown around and used quite liberally amongst various professions. If you were to line up a lawyer, a tax accountant, and a financial advisor and ask them, what is an estate plan? You'd probably end up getting 3 very different answers. So I've attempted to try and amalgamate all of those answers into one straightforward definition. In essence, what an estate plan is it's a plan to ensure that your assets that you've accumulated during your life are properly managed over the course of your life in the event of an incapacity and after you've passed away, to ensure that those assets are properly distributed in accordance with the instructions that you've left. So not all plans are created equally. A good estate plan will ensure that the assets that you've worked very hard to accumulate over your lifetime are preserved. So working with an estate planning lawyer, a financial advisor, and a tax advisor, the goal is to ensure that your assets, number 1, are preserved, and number 2, properly managed. Now, if we look at this definition, you're going to see that there's really 2 aspects to creating an estate plan. There's the plan for while you are alive, and then there's the plan for what happens after you pass away. So how do we create this plan, and how do we implement it? Well, the short answer to that is you implement the plan both during and after life by the creation of a will and a power of attorney for property and a power of attorney for personal care. So these 3 documents, they formulate the foundation of a basic estate plan. The powers of attorney, these documents are your estate plan for during your lifetime. And what that means is that the powers of attorney, these documents are only legally enforceable. They can only legally be used while you are alive. The moment that you pass away, these documents become null and void. So to ensure the proper management of your assets over your lifetime, as well as your care, we turn to your powers of attorney. Once you pass away, your will becomes the effective legal estate plan document that will govern and oversee how your assets are to be distributed after you've passed away. Now, by comparison, during your lifetime, your will is not actually a legally enforceable document. So what that means is that if you ever wanted to change it, amend it, revoke it, tear it up, whatever you want, you have the power to do so. And you will not be held to, once you have created a will, you will not be held to have to keep that same will. And part of the reason for why that is it would create quite a bit of problems if people were trying to enforce wills against individuals who are still alive. So to give you an example, if you had a will that said, I leave everything to my children, and one day your children woke up and decided, you know what, I'd really like my inheritance now, rather than, when after mom and dad pass away, and they have a will saying that they've left everything to me, I'm entitled to it. They are not entitled to it. They are absolutely not entitled to it. You have the ability to change your will at any point in time, provided that you have the capacity to do so. And just to be clear, only you can create a will, and only you can change your will. Nobody else has the power to amend any of these documents that I've just described, a will and powers of attorney. Now, what happens if you don't have any of these documents? What happens if you don't have this basic estate plan? Well, then a plan is made for you. The government wants to ensure that assets are simply not left in limbo. They have to be managed by somebody, and they have to be distributed by somebody in the event that that person passes away. So the government has actually created what I like to refer to as default estate planning rules. Now, the problem with these default estate planning rules is that you may not like what those rules say, because they are very, very basic, and I will provide some examples as to what those rules actually are. So one of the benefits of creating an estate plan is to ensure that you have control. You get to make the decisions as to what happens to your assets, rather than leaving it in the hands of the government, who, while well-intentioned, may not end up having your assets administered or distributed in accordance with how you would have liked it. So having the opportunity to sit down and put together an estate plan ensures that your wishes are to be followed, and that those wishes are simply not made for you on your behalf without your input. So next, oh, I went too far. We are going to talk about what a last will and testament is. My screen is, there we go. Okay, so as I mentioned, that a last will and testament during your lifetime is technically not legally enforceable. It sits in limbo, but the moment that you pass away, that is when it becomes legally effective. So what does a will do? Well, it does two basic things. Number one, it names an individual or multiple individuals, and we refer to these individuals or individual as an executor. And the executor is the person that is in charge with overseeing the administration of your estate. And I'm going to discuss what administering your estate actually means. The second main thing that your will is going to do is it's going to provide instructions to that executor as to how you want your assets to be distributed. Your executor must follow those directions. They do not have the ability to read what it says in your will and decide, you know what, I disagree with that, I don't like those instructions, and do something totally different. If they do that, they're acting inappropriately, and there are large repercussions for doing so. So your will is going to appoint the person that's going to oversee the distribution of your assets after you've passed away, and you're leaving instructions as to how you want those assets distributed. Now, what does the actual process look like? And that's what I refer to as administering an estate. Process for ensuring that assets are transferred to the named beneficiaries. Well, that process will vary from estate to estate, and it will depend on your personal circumstances. It will depend on whether you're married and have children, whether those children are under the age of 18, being under the age of majority. It will depend on the type of assets that you own, real estate, a business, bank accounts, things like that. So in naming your executor, the number one qualification for ensuring that your estate is properly administered is to ensure that you trust the individual that you have named, because you are giving them quite a bit of power. You're giving them the power to take control of all of your assets after you've passed away, and you are trusting them to ensure that they will distribute those assets in accordance with your instructions. So number one, when considering executor, you must trust them. If you don't, do not name this individual. Now, as I said, the process for administering estate varies from estate to state, varies from estate to estate. But just to give you a basic guideline as to what that process looks like, when somebody passes away, the executor's first job is to preserve the assets. So what that means is take control. So if you have a home, if you have a bank account, if you have a vehicle, all of those things, the legal ownership of those things are going to need to be transferred into the executor's control, whether it by name or some other means. Once the executor has control of your assets and preserves them, the next step is to pay all taxes that are due and owing. So there's going to be a common theme throughout my presentation and Akshay's presentation, which is the government is lurking around the corner. They need and want every bit of tax dollars that you can possibly, or that they can possibly get out of you. So before any assets can be distributed to beneficiaries, your executor needs to ensure that all of the taxes that you have accumulated in the year that you've passed away, or as a result of your passing, are paid, because CRA rather gets first chop. They get to be paid before all beneficiaries. Once your taxes are paid, your executor is responsible for then ensuring that any debts that you have to be wound up and paid. So credit cards, things like that. And then finally, once your taxes and debts have been paid, they can distribute the assets in accordance with the instructions on your will. It sounds relatively simple from a high-level perspective. Having gone through it more times than I can count at this point, it is anything but simple. However, having an estate plan that reflects your wishes will do two things. Number one, it will ensure that your assets are distributed quicker than if you had not had an estate plan, because then things tend to get a bit more complicated. And number two, if the estate plan has been drafted properly, it will ensure that more of your assets are preserved, meaning that the individuals that you want to receive your property get more because there's been a proper tax strategy put into place. There's been assets that have possibly been transferred by ways of beneficiary designations and things like that to minimize the amount of tax and debt that may have to be paid in the event that you passed away. So a good estate plan will make sure that your assets are transferred quickly and efficiently. Now, moving on to the discussion of your power of attorney for property. So as I said at the outset, your powers of attorney, and there are two forms of powers of attorney in Ontario. You have a power of attorney for property and a power of attorney for personal care. Your powers of attorney, these are your estate planning documents for while you are alive. And what these documents do is they allow you to appoint one or more persons on your behalf to make certain types of decisions in a situation where you are alive, but you're incapacitated. So incapacitated meaning that mentally or physically you cannot do what needs to be done in order to pay your bills, taxes, etc. So the powers of attorney are broken down into two types, and we're going to first focus on a power of attorney for property. So what this document is allowing who you have appointed to do is to take control of all of your assets. So think about everything that you currently own, and your attorney for property, that's the person who you appoint, has the ability during your lifetime and in the event that you're incapacitated to take control of all of those assets on your behalf and manage them for your benefit. And that is the threshold. They must manage your assets for you. So again, ensuring that who you appoint under a power of attorney for property, you need to make sure that you trust that individual, because they will have control and decision-making powers over, do we buy this asset, do we sell this, and also responsible for ensuring that your bills and debts are paid. Now, if you do not have a power of attorney for property, as I said, there are default rules. So in this case, the default rules appoint a branch of government called the public guardian and trustee to be able to take over and take control the management of the assets that you own. So to give you a practical example, somebody was involved in a car accident, they can no longer look after the management of their assets, they can no longer pay their bills, they can no longer do their banking, they can no longer work, and they do not have a power of attorney for property, then this branch of government, the public guardian and trustee, is going to step in. They're going to appoint somebody who is then going to take control and make all of these decisions for that person. So as I said at the outset, putting together an estate plan allows you to control who do you trust, who do you want to take over this type of responsibility if that type of situation were to arise. Now, I've worked with the public guardian and trustee on a number of matters, and they are a very important function in our society. They represent disabled individuals who do not have representation. That said, you do not want them anywhere near your assets or taking control of those assets, not because they're bad people, but because, like most government branches, they are overworked and they are underfunded, and they will find the cheapest, quickest way to organize the management of your assets rather than somebody who will look at it and ensure that your wishes are followed through, and then they will move on to the next file because they're too busy. So ensuring that you have a power of attorney for property will avoid and prevent that branch of government from stepping in and taking control. Onto your power of attorney for personal care. So this document functions much in the same way as your power of attorney for property. It is only legally effective while you are alive. It will come into effect in a situation where you are incapacitated, and it will allow you to appoint somebody, in this case, to make what we refer to as personal care decisions on your behalf. So this document is often called or referred to a living will. What are my wishes in the event that I am alive, I've suffered some catastrophic injury or disability, and what care am I to receive? Am I to undergo certain medical procedures or not undergo those procedures? Am I to take this medication versus that medication? What sort of care will I receive? Will it be in-home care? Will I be put into a care facility? This is the document that appoints, again, the individual or individuals who is going to be responsible for making those types of decisions. So once again, you need to make sure that who you name in this document, you trust, and you need to convey your wishes to them. You need to let them know that if I am suffering from some form of debilitating illness, do not revive me. Or if your wishes are continually revive me because I'm hopeful that a certain cure or procedure will be implemented, those can also be your wishes. Again, it's a question of what do you want and making sure that those wishes are followed through. Now, what happens if you don't have this document? Again, there are default rules, and in this case, the default rules allow for any blood relative, so brothers, sisters, mothers, fathers, children, cousins, aunts, uncles, any blood relative of yours, including spouses, although they're not blood related. So any blood relative and spouses are allowed to make these decisions for you. So what this document is doing is it is elevating the person or persons that you trust the most to be able to make these types of decisions, and it's elevating them above everybody else. So again, ensuring that you have this document means that you have spoken with somebody, you've told them what your wishes are, and you trust them to implement those wishes. So we've gone through and we've touched on what a will is, what a power of attorney for property and personal care are, and let's talk about the importance of putting it all together. Now, I have alluded to this through my presentation, which is it boils down to control. Do you want to be able to make these decisions now while you are you're alive, you've got capacity, you have the ability to think about things in a clear mind, or do you let the decisions be made for you, or have the decisions be made in an emergency situation? So an emergency situation, for example, would be somebody suffering from a terminal illness. They don't have a will, and I'm called in to take instructions. That person may not be thinking as soundly as somebody who has the ability to sit down and contemplate, what are the consequences or how they'd like to formulate their plan. So preparing a plan, an estate plan, allows you to look ahead and ensure that your wishes are followed. And without the plan, your assets can be distributed in ways that you don't want or anticipate. I've had many conversations with the surviving spouses and children of individuals who passed away without wills, and I have to tell them what the default rules are. What happens? What is the consequence of not having a will? And generally speaking, the response is overall not very well received because of what the rules say. So having the ability to sit down and prepare an estate plan, it ensures that your wishes are followed and ensures that you have control over those decisions. And a basic estate plan consists of a will, a power of attorney for property, and a power of attorney for personal care. And that's everything that I wanted to touch on for right now, because those items, they formulate your basic estate plan. So thank you very much for listening. I am now going to hand things over to my co-host, Akshay. Akshay is a financial advisor with Edward Jones, and he is going to speak on the topics of life insurance. So very quickly, life insurance is a tool that is used in the course of putting together an estate plan. And so with that said, Akshay, I'm going to hand over control of everything to you and let you take it from here.
Great. Thank you so much. Good morning, everybody. Very happy to be here. I want to thank the OTF and Keith. It's a beautiful Sunday morning, but I appreciate everybody taking a few minutes to be able to, learn about this very, very important topic. So I'm going to share my screen. One sec. Okay, is everybody able to see my screen?
Yes.
Yes. Yes.
Perfect. Thank you so much. Okay, so again, before we jump into the topic, I just want to kind of introduce myself. So my name is Akshay. I am a financial advisor with Edward Jones. I do believe throughout our life, we're always going to be faced with making decisions. It could be something like where to buy our house, or what car we want to buy, or how we want to handle our investments, how we protect our family, big or small. The best decision is always going to be an informed decision. So one of the things I'm very, very passionate about is helping educate people and give them the most information possible so that they can make the best decisions for themselves. And when I work with my clients, there are three outcomes that we're always looking for. So one, we always want to make sure people are feeling very confident about achieving their goals. We want people to feel very secure with the amount of risk that they're carrying in their plans, and are those risks being appropriately managed? And the last, and perhaps one of the most important, is we want everyone to feel informed about their true and total cost of whatever decisions that they make. And often that attaches cost to things that we don't do, as opposed to some of the actions that we do take. So, having said that, estate planning and wealth management, it does require a lot of thought. It takes a lot of preparing, and it takes a lot of planning. And um, when we have a financial strategy in place, the important part of that is protecting it. As a financial advisor, on the one hand, we help families build and manage their wealth through our investment license, and then we also protect those plans through the insurance license. So building the plan and trying to make our way to achieve that is great, but if we don't have the right protection in place, there's a whole set of risks that we're exposing ourselves to. So one of the things that I think most of us can relate is, as first or second generation Canadians, we're all working very, very hard to build a better life and seek new opportunities for the prosperity of our families. And again, what we don't want to do is to spend a lot of time and effort building this great new life and providing these opportunities for our family, to have everything get derailed because of an unexpected event. So what we're going to look at is the role that insurance has to play in your overall financial strategy, and in particular with the estate planning that Keith has gone through for us. So as we go through this, I mentioned it's a beautiful day, not always a comfortable topic, but I would say instead of becoming fearful or becoming very uncomfortable, throughout this, think about how you can proactively develop a plan and what strategy you can put in place that's going to protect your family. So the one question to maybe keep in mind is, how would the security of my family and my own security be impacted if I passed away or had a serious health change? So kind of keep that question top of mind as I kind of go through the next series of slides. So insurance is something that many of us will understand just from the point of view of how home and auto insurance is a requirement. And insurance is all about managing risk and protecting against loss. So as we prepare for the unexpected, our life and our legacy needs are something that we also do need to protect. So there are different types of insurance that are available for different needs, and today we're primarily going to focus on life insurance, but what we're seeing here in this visual is the blue side here is generally kind of through our working life, and as we accumulate wealth and we build up our assets to the point where we're able to retire, and then the yellow side is kind of when we're actually living in retirement, and this is typically when estate planning takes on a whole different perspective. So through the course of our kind of working life, the primary insurance coverages that most people would be looking to get protection from would be life insurance, critical illness insurance, and disability insurance. And then when we cross over into retirement, life insurance still has a significant role to play, but there are other insurance coverages that might be appropriate, such as long-term care, or other insurance products or contracts. Things like segregated funds or annuities may be appropriate. So it all depends on a personal situation, and although we're all looking at the same kind of goal, each individual is going to have very, very unique considerations. So that's one of the big values of insurance, is that it's an extremely flexible and customizable tool. Also, if there are any business owners, whether we're talking about during the working portion or even in the retirement portion, there are a lot of unique business insurance solutions, such as key person business overhead or even buy-sell agreements. And again, we could probably spend the entire day going through all these things, but again, for the interest of time and the focus of our presentation, we're going to be working with the life insurance. So early on, we typically look at insurance during our working portion to kind of cover off any liabilities that we have, to replace lost income in case we've lost our ability to maintain our jobs, and basically make sure that our goals to kind of finish off our working life, we're going to be protected through there. And then once we pass kind of into the retirement side, we want to be able to preserve our assets and make sure that our intended legacy, or what we want to leave to our loved ones and beneficiaries, is going to be adequately funded. So one of the biggest questions I'm sure most of you are going to have is, what am I going to pay? And unfortunately, that's not something we're going to be able to answer, primarily because, as I mentioned, it's very, very customizable. It's going to be very, very unique. So what it boils down to is what's important to you and what are the risks that you are looking to protect. And based on that customizable solution, along with things like your age and health status and multiple other factors, that's going to determine the price. So the important part is making sure that we're covering all the things that are going to be important to you. So we kind of touched on this on the last slide, where it was a little bit easier, but again, earlier in life, we're typically going to be focused on saving for and protecting our long-term goals. So when it comes to insurance or life insurance, there are two main types. There is term or permanent. So term is a bit of a temporary insurance, which is great. It's a great place to start because it's typically very affordable, and it's a great way to just kind of get started. And if we think of one of the biggest needs we'd be looking to protect is our mortgage. So a mortgage is typically a temporary need. After a certain period of time, we expect that mortgage to be paid off, and then we're not looking to seek that protection. So it doesn't make sense to pay our entire life for something that is a temporary need. So hence, term insurance is something that we would use to cover off those kinds of needs. Other things, if we have our final estate taxes, if we have our funeral expenses, whatever our legacy goals or inheritance that we want to leave to our family, that's going to be with you for our entire life, because the event of our passing is going to trigger the need to fund those goals. So that's where something like permanent insurance becomes a little bit more valuable and more appropriate. So one of the things that I'll say about term insurance is that It's one of the great places to start because it's affordable. And typically earlier on in our lives when we're just getting started, especially with young children, we have a lot of financial responsibilities. So what we want to be able to do is do everything we can as efficiently as possible. But the value in acquiring a quick term policy is that you're guaranteeing your insurability. So I mentioned there are a number of factors. Our insurability gets locked in with a term insurance, and that term insurance can be renewed periodically, or you also have the option at a certain point to convert it to permanent insurance, which could be a little bit more pricey, but at a later stage in life when you have the capacity to be able to afford it, then you're able to kind of make that switch. So locking in our insurability is one of the key pieces, and insurance is one of these things is that the older we get, the more expensive it gets. Because again, life insurance will be paid out upon our passing, and whether that's going to be a year from now or 80 years from now, every day or every year that goes by gets us that much closer to that event, and we don't know when it's going to be. But because we're always getting a little bit closer, it becomes a little bit more expensive as we go. So, um, so understanding which type of insurance and what's the right coverage and what you're paying for it is really the basis of kind of starting that discussion. Now, when we look at again in the early part of our life, we actually use the acronym LIFE to assess needs. So, what are the liabilities that we're looking to have paid off in the event of our passing? So, this could include things like your mortgage, if you have any car loans or student loans, credit card debt, lines of credit. Any of these types of things are typically the liabilities that we do not want our loved ones to have to pay once we're gone. And especially in a situation where if an individual is the primary earner, that places a huge burden on the surviving spouse to be able to kind of raise children and kind of pay for these liabilities. So typically we want to make sure these are paid off. Then we've got the I in life stands for income replacement. So if we pass during our working years, any of the income that we would have brought to the family through the course of our working life, all that's going to be gone now from the family. So typically we would look to calculate how much of that income would the surviving spouse need and for what period of time. And that's going to cover things like living expenses, what are the savings for future needs, and often it's a place where we'll create an emergency fund to help with transition costs. So typically we would be looking at covering income until the youngest child turns 18, because at that point they're not a dependent. But in a lot of cases, a lot of families will choose to add on another 4 or 5 years to be able to support, support their children through post-secondary education. But again, it's all going to depend on the individual need. One of the questions I get asked a lot is for if one spouse is a stay-at-home spouse and they're focused on raising the family or they've got a small part-time job. There's also a ton of value that that individual is bringing to the family because in the event of their passing, even if they're not working, the surviving spouse as the primary earner will have to continue to work. So now if there are children, there are going to be new costs that were not part of the original household budget, such as childcare costs. Or even maintenance around the home or whatever the case is. So again, just because we're not working doesn't mean that there's not a lot of value attached to what we're bringing to the family, and there could be a big financial risk that's going to be exposed. The F in life stands for final expenses. So this is where we would be looking to cover things like funeral costs, burial or cremation costs, estate fees can be a big liability that's going to erode our assets. And again, final taxes, depending on the nature and type of assets. If we have a cottage or recreational property, or if we have multiple investment properties, there could be a significant tax burden that's placed on the beneficiaries. And unfortunately, sometimes the only way to pay that tax bill, as Keith said, the Canada Revenue Agency is always first in line with their handout. So they're going to have to get paid first. So sometimes those assets would have to be liquidated in order to pay the tax bill. Which it also creates a little bit of wealth for the beneficiary, but the asset itself is gone. So if it was important to you to hold on to that asset, sometimes that doesn't work out. So that's something that we need to look at. And in terms of short-term expenses, sometimes there could be a period of transition. It could be a while before the surviving spouse can go to work. So, how are you going to manage the day-to-day bills and kind of save for the longer-term goals? So these would all be kind of considered under final expenses. And then education. So if we have children, paying for their current needs, if they're in some sort of a private institution or they're doing any extracurricular education programs, but also in terms of post-secondary education, which we all know is very, very expensive. And for a lot of people, it's also important to them that they're able to help out with the generation following, with their grandchildren, and they want to help their kids by helping set up their children's or their grandchildren's education. So again, it all depends on kind of what's important. So these are the primary needs that we would look to determine what is the appropriate amount of coverage for your particular situation. Now, again, in the second kind of part of life, kind of during retirement, this is where we're going to start living off of our savings. But again, we want to make sure that our assets are going to last long enough for retirement. We never want to be able to outlive our money. But again, depending on what our legacy goals are, we may not be able to fund our lifestyle as well as provision those goals. So this is where life insurance can really help you live a comfortable retirement and let you preserve your assets for that lifestyle and still be able to create the funding for those legacy goals. One of the other big values here is being able to transfer wealth efficiently. So from a financial perspective, the estate plan will include wealth transfer strategies. And as an example, a solution like segregated funds is a great way to be able to pass on your wealth discreetly, very quickly, outside of probate, directly to a designated beneficiary, and that's always tax-free. So, if you have specific dollar amounts you want to leave to loved ones or grandchildren or charities or causes that are important to you, this is one of your big considerations over here. So what we're really looking to do is basically reposition assets throughout your life, either in the working years or even in retirement, to be able to keep your assets protected from unexpected costs or costly liquidations that may have to come up unexpectedly. So, as with making sure our wishes are going to be followed and we're going to be able to make sure that everything passes the way that we want. This is where the value of insurance is going to give you all of those choices and give you the maximum opportunity to kind of preserve our estate. So from a permanent insurance point of view, your permanent insurance is going to be in force for life. And as long as you continue to pay the premiums, and whether it's on a set schedule or until we actually pass away, nothing will ever take that insurance coverage away. And the benefits that are paid out from life insurance policies are going to be free from income tax. So that's always passed on a tax-free basis. So this is how you can create your legacy, and it's also how you can finalize your estate and make sure all the goals that are important to you are going to be adequately funded. One of the other big things in terms of permanent life insurance is that they, whether we're talking about a whole life policy or a universal life policy, they do accrue wealth in terms of cash values, and it's usually a very tax efficient way to build up additional wealth and be able to kind of pass that on, and they come with their own investment options within the insurance. So in terms of for the later stages in life, when we look at what some of those goals could be, I've talked at length about a family inheritance. So how much you want to leave, and the amount that you intend is going to be paid out, because as Keith mentioned, the CRA will be first in line, and you don't want an unexpected tax bill eroding most of your assets, and then your beneficiaries don't get the intended amount. So again, that also brings to light that a very solid and sound estate plan is going to include the legal expertise, the tax expertise, as well as the financial expertise. And that's what's really going to protect you. If you have specific charity or legacy plans, if you wanted to start a scholarship, if you wanted to fund a community group, or your local church or temple, these are all ways that if you don't have the capacity to build those assets, but it's something that's very, very important to you, you're able to fund it by ensuring that the total life insurance benefit, it has that provisioned. So one of the big topics that tends to come up is estate preservation or equalization. So when we're talking about estate preservation, like I said, if we have a finite amount of assets, but we have multiple goals, sometimes we may not be able to prioritize to our satisfaction, or we might not be able to kind of have the trade-offs that we are willing to make. So what we can do is ensure that we can kind of fund all of our goals and live the life that we want by making sure that we have adequate protection. But from an equalization perspective, the example would be if you had a property that you wanted to leave to, you have two children. One child says, I don't want to be burdened with property management. It's not something that interests me. But the other child does want to kind of maintain that investment property and kind of keep up with the tenants and all that kind of thing. So one of the ways, instead of having to liquidate the asset to make sure both children are treated equally, you can actually create the monetary equivalent through insurance to be able to pay out the one child, and the other child would get to actually get the full value of the property. So in a way, you're able to kind of equalize your inheritance for the two different goals. I've already spoken on the intergenerational wealth transfer, but one of the things that's actually becoming a little bit more popular is, again, because insurance proceeds are tax advantaged, there's also tax advantage growth within certain policies. It gives you that ability to transfer to future generations. And in some cases, with an appropriate laddered policy, which is too complex to get into right now, you could potentially be setting up your grandchildren or even great grandchildren. So taking the right steps today could actually fund 4 generations of your family in terms of giving them that start to have that prosperity for the family. Also, if you have a business or you own farmland or any other additional real estate, this is also a place where we can generate the wealth that's required to be able to pay for ongoing maintenance costs, and as well as paying for other probate fees and final taxes and things like that. So again, it's all about that efficient transfer of wealth. So basically, again, whether we're talking about an investment side or a insurance side, the 5-step process that we use is it's always going to be the same, but the details are always going to be unique for every individuals. But you always need to understand where you are today and where do you want to be. What is that goal, and what does the achievement of that goal look like? And then you need to understand, is it a realistic goal? Can we actually get there? And then once we have established all of that, that's when we figure out what's the road plan. What are the solutions that are going to help me get there, and what's that roadmap? And then life is going to change. It's going to change within your family, but it's also going to change in the world at large. And this pandemic that we're under right now is a very good example of how unexpected events can turn things around very, very quickly. So staying on track and doing periodic reviews are very, very essential. And when we work on estate plans, who we've named for a beneficiary, maybe a will that was done 10 years ago might not be the same. Our chosen individuals for power of attorney, or our executor, or the named beneficiaries in our accounts sometimes those things will change. So it's important for periodic reviews, no matter what your goals are. But you always want to make sure that you're always going to be on track, no matter what life throws at you. So one of the things that I will say is that there's really been no better time than now. So whether you have existing coverage or you don't have any coverage at all, understanding what's the right amount is very, very important. Understanding what type of insurance you have is very, very important. What you need, and are you paying the right amount? And there's really been no better time than now, because as a result of the pandemic that we're under, we do have, we work with Canada Life, Manulife, and Sun Life. So we work with three of the biggest insurance companies. They've all pivoted to what they're calling accelerated underwriting. So typically, a lot of the requirements where you would have face-to-face, or you have the medical, you have or what they call paramedical with fluids, with blood and urine samples and things, they've actually waived all of that, and now things can be done digitally. Things can be done through a phone questionnaire, and in some cases, they may ask for what they call an APS, or a attending physician statement, and that's usually enough to get the applications processed very, very quickly. So again, it's actually probably one of the best times to be able to get our needs covered in a very quick and efficient fashion. So yeah, I think that's a good place to leave it. Now, and Keith spoke at length and in a fair bit of detail. And again, I kind of covered off the insurance side of things, but to kind of maybe help bring a lot of that theory to life, we wanted to walk you through a scenario. So this is a scenario that actually happens more often than not, and it's definitely not a place where any of us want to find ourselves. So in this scenario, we're going to look at a family that they were basically thinking it won't happen to us. So I'm going to set the stage, and then Keith will be able to jump in and weigh in on a few thoughts, and then I can perhaps add a little bit of color as well. So in this particular case, we have the Kapoor family. So we have our parents, Sanjay and Nisha. They've been married for 13 years, and they've started this exciting life, and they have two lovely children. They have their daughter, Neha, who is 10 years old, and their son, Rohan, who is 8. And, they've been working very, very hard. And one day they decide, you know what, we're going to go out and we're going to go out and enjoy a nice dinner, just the two of us. So before they set on date night, they get a babysitter, everything's okay at home, and they go out for the evening. Now, unfortunately, on their way back, the weather turned a little bit bad, and they were involved in a very, very serious auto accident. So unfortunately, Sanjay passed away as a result of this accident. And Nisha, unfortunately, she was very, very severely injured, and she became incapacitated, and she ended up in the hospital. So we don't always know, or we don't expect these types of tragedies to kind of impact our families, and this young family certainly didn't. But if the truth is told, if we look around and consider all the people that we've known over the years, we've always known somebody that's been impacted through some sort of a major accident, and the unexpected actually happens a little bit more often than we think. But in this case, their world has been turned upside down, and what are some of the impacts of this situation? So as a result of this accident and Sanjay passing away and Nisha being hospitalized, the big considerations are, how are they going to pay for the funeral, and who's going to make all those arrangements? Sanjay, again, being very, very young with young children, he's lost his income for what would have typically been the working portion of their lives. They do have an outstanding mortgage that was fairly sizable. Again, their children being young, they had just started the education savings, so they don't have nearly enough to be able to fully fund their children's education. And now all of a sudden, there's Nisha's medical costs. And as part of the medical costs, we're fortunate to have a very good healthcare system here in Ontario. But The other part of that is not just the actual cost of the medical treatment, but recovery. And it could be years of potentially physiotherapy. The home may need to be, renovated to be able to accommodate her new incapacities if she has any, and all those. So there's a lot of immediate costs and a lot of financial stress that's brought on right away. And not to mention that Nisha won't be able to work either. So at least not for a period of time. And then there's also a lot of very important decisions to be made. So who's going to be looking after the children while Nisha's in the hospital? Who's going to take care of any of the investment decisions, which includes the education planning and all that, and making sure just the bills are paid and all that. So without having any kind of an estate plan in place, there are a number of risks that this family is now exposed to. So having said that, Keith, maybe you can take over and maybe give us a perspective on some of the impacts and what are some of the steps they could have taken and what the value of those steps would be.
Okay, perfect. Thank you, Akshay. So this scenario covers quite a few estate planning items, and I'm going to try and keep this as simple and straightforward as possible. So starting with husband has passed away, I'm going to assume in this scenario that he does not have a will. So as a result of not having a will, his estate and his assets are going to be transferred pursuant to the default rules under the province of Ontario, which in this scenario would mean that his wife would receive the first $200,000 of his estate, and then whatever is left over and above that $200,000 of assets will be distributed equally between his wife and his two children. So this poses a couple different problems. Number one, if his intention was for all of the family assets or all the assets that he had accrued over his lifetime to pass to his wife, that may not occur, or frankly, it may not occur depending on what the value of those items are. Number two, if the children are in fact entitled to receive a portion of their father's inheritance, because they are under the age of 18, this money will have to be held in trust for them until they reach that age. And without an executor who's named under a will, one of two things is going to happen. Number one, somebody is going to step up, a family member, a friend is going to apply and to the courts, the Superior Court of Ontario, where if somebody passes away without a will, a family member, and in very limited circumstances, friends can step up and apply to be appointed as an executor. So somebody will need to do so and then hold on to those children's inheritances and manage them until they reach the age of 18. That would be option number one. Option number two, if nobody steps up and nobody wishes to apply to the court, become the executor, then the public guardian and trustee is going to step in, and again, the government is going to take control of the estate and management of these assets, which again, you typically and very strongly advise against and want to avoid. So that's the consequence of not having will. The second topic that this scenario addresses is the fact that Nisha now may require somebody to make certain types, to take over and manage her assets and make personal care decisions for her. So the scenario doesn't say exactly the extent of her injuries, but let's assume for a moment that they were catastrophic and she required full-time care. And if she did not herself have powers of attorney, then number one, the public guardian trustee will take over as as managing her personal assets, which will have a trickle-down effect to the children because the assets that mom owns will ultimately be used for the children. And number two, somebody from her family will have to again step up and act as the individual making all of her personal care decisions. So without those documents, again, those types of matters are left to the default rules, which may not result in what Nisha what would have wanted to have happened in this scenario. Now, the last issue that I just want to speak on is guardianship for the children. They're under the age of 18. If Nisha is not able to look after her children, she's not able to care for them, then a guardian of her children is going to have to be appointed. And there's two ways that a guardian can be appointed for a child who's under the age of 18. Number one, somebody will have to apply to the court, Superior Court of Ontario, and be appointed as that child or both of their children's legal guardian. So again, a process is going to have to be involved, and that process could have been simplified if Nisha had a will. Oh, actually, in this case, no, the will wouldn't come into effect. So no, the will is actually left out in this case. So somebody's going to have to apply to the court and be appointed as these children's legal guardians. Number two, scenario, or the second potential outcome, if nobody applies to the court, then the children are ultimately going to be handed over to CAS, the Children's Aid Society, and they will be placed with somebody who can care for them. Again, not an optimal outcome. So having an estate plan and talking to the individual who you would want to look after your children, or Nisha's children in this case, in the event of death or incapacity, would have ensured that those children don't end up going with CAS. So those are really the three estate planning consequences that result in this scenario because they didn't have those documents. Actually, I'm going to hand it back over to you and have you speak on the financial burden that the family now in this scenario has to undergo and what they can do, what they could have done.
Thank you, Keith. And so obviously there's deep impacts and unintended consequences that could arise, as Keith has illustrated. And I think the one that would, well, personally for me as a parent, the guardianship of minor children would be probably the most important part to me. So there's that. Now, in this particular case, again, based on the scenario, their feeling was, okay, look, when we got our mortgage, we took out mortgage insurance at the bank, so we're kind of covered, and we've got work insurance. I'm part of a group plan through my employer, and we'll be okay if something kind of happens. So if that's what they were relying on, the financial impacts or the consequences here is that, for the sake of argument, let's suppose your mortgage was for $300,000. The gap there is that, yes, the mortgage will get forgiven, but in this particular case, let's suppose when they first bought their home, their mortgage was $500,000. Now, they've chipped away at it, and now it's only down to $300,000. The beneficiary of that insurance is actually the bank, because a check for $300,000 will be cut and it's going to go straight to the bank. So the family gets no benefit out of it. Now, when they had taken out their mortgage, had they had a life insurance policy for $500,000, today the check would be made out for $500,000 and it would go to the family, of which they can use $300,000 to pay for the mortgage, and they would still have the benefit of the other $200,000. That benefit does not decline over time. So that's one of the quick things that they could have done, is rely on a personal private insurance policy where they are the beneficiaries and that benefit does not decline over time. One of the other, I guess, thought processes that Sanjay had was, I'm covered under my employer group plan, so you know what, I'll be okay. Group plans or group insurance is really, really good from the point of view that it's very, very quick, it's very, very affordable, and there's actually no kind of underwriting or medical history or anything like that. But as a result of that, it's a bit of a kind of one size doesn't fit everybody solution, where he was making a salary of about $80,000, and under the terms of the employer-sponsored insurance, it was in the event of unexpected death, it would be a 2-year salary benefit. So In this case, the check would have been $160,000 based on his 2-year salary. So the $160,000 would not begin to kind of, make a dent in all of these costs that are now being faced by the family. So while those plans are good when they're available, and it's a kind of a good place to start, understanding what is it that that full need is, including the secondary education costs for the children and things like that. The amount of coverage is actually not appropriate, so that introduces another big risk. Now, Nisha, she had a good job as well, and as part of her employer-sponsored plan, there was also a disability component, but that disability insurance covers about 60% of her income for 6 months. So again, understanding the terms of those employer plans is really, really important, because if her recovery could take up to 12 months before she's fully able to go back to work, 6 months of that disability coverage of 60% of her income is not going to be enough to maintain the house, let alone kind of prepare for any of the future needs or things like that. So even if we feel we have coverage, whether it's through employer-sponsored plans or mortgage plans or even a term policy that was maybe taken out some time ago, as life evolves, as our needs expand, it's really, really important to make sure that we're doing the review to ensure that we have the right type, the right coverage, and the right cost of insurance that we're looking at. So that's just a quick summary in terms of what they could have done is, with the right assessment in the beginning, had the private insurance for the maximum benefit of the family, but then also moving forward that it was reviewed to make sure that it was going to be sufficient. So, Keith, unless you have anything else to add on this, then maybe Murali, we can send it back to you, and you can maybe open up for general question and answers.
Thank you, Akshay, and thank you, Keith, for the wonderful presentation. We now open up the forum for questions. We have received some questions earlier, and I'll quickly go through them. If you are okay with it, I'll post them to you, Akshay.
Certainly. Okay, we're ready.
Okay, some of the interesting questions that we saw the other day, or people have posted while registering for this session, is one of the first one that came in was, is this will and trust estate planning executed here valid worldwide, or is it going to be only in Canada?
Okay, I can speak to that question. Canada has entered into international treaties with a select few countries where a will that is prepared in Canada will be recognized in a different country. So the answer is it depends, and it depends on what that country is, and whether that what the country is, and whether that country has entered into an international treaty with Canada. The long answer to that question is that even if a will that is prepared in Canada can be recognized in a different country, whether that is a good idea is going to be very much dependent on what that country's estate planning laws are. So when I have clients that have assets in multiple countries, my recommendation is always the same, and that is prepare a will in Canada with a Canadian lawyer who understands the estate planning laws in that country, and for your assets that are in a different country, get a will done that deals only with those assets, and have it prepared with a lawyer or a notary or a professional who is familiar with the estate planning laws in that country. And you end up with multiple wills dealing with each sets of assets. In some extreme complex situations, you're going to need tax advice as it relates to the transfer of assets between countries. So again, it's going to depend on which country it is and what the international tax rules are or tax treaties that Canada and that country have entered into. So to summarize, can a will be created in Canada be recognized in another country? It can be. Whether it is, can't guarantee it. I'd have to know what the country is. But should you create one will that deals with all of your assets worldwide, I generally don't recommend it. And that's because the estate planning laws vary from country to country.
Thank you, Keith. The next question that we have is, can we make a will remotely? If so, what is the process?
So as of the first week of April, the province of Ontario implemented new emergency provisions that allow us to take will instructions virtually and to have wills signed virtually. Before that first week of April of this year, a will needed to be signed in person. I needed to physically sit across a table from somebody and watch them sign a will. And this is a fraud prevention mechanism and to ensure that that person is not being unduly influenced by anyone. Those rules have since been relaxed as a result of the global pandemic, and now we are able to do everything virtually. What the process looks like, having been going through it over the last couple months, is you'd have an initial consultation over the phone or over video conference. The documents would be prepared, they'd be delivered. A review of those documents would take place, and then the final signing of the will would take place over a video call. Now, one of the conditions that the province has imposed is that if a will is going to be signed virtually, so it's going to be witnessed virtually, one of the witnesses must be a lawyer. So if you're going to try and do it virtually, you need a lawyer. You can't have anybody else act as a witness on that will. But the short answer is yes, we can do it virtually now.
Thank you, Keith. Most of the other questions that we have been answered. One thing before I hand it over to our audience is, what would be the validity of the will?
So I think for this question, I need a bit more context with respect to what validity is referring to. I mean, is the question asking what makes a will valid, or how can a will be challenged? I think I need a bit more context before being able to answer this question.
Sure, Keith.
Is that will is going to be expired? That's what the question is. Once we write a will, it is going to be expired, or it is there forever, what we have been said, until the executor or the whoever we have been written, until those guys have been taken it. So that's what the question is.
Okay, thank you for clarifying. So once you prepare a will and it's signed and it's properly executed, it is valid forever. It does not expire. And the only time that a will not be valid is when it is amended or revoked. And only you, as the individual who is preparing the will, can do that. Nobody else can revoke or amend your will. But otherwise, once it's in place, that's it. It's valid, and you don't have to be concerned about it expiring in any way.
Thank you.
Thank you, Keith. I'll open the forum to our audience to ask questions. You can unmute yourself as well as open your video too. Thank you.
Yeah, hi, Kate. This is Pradeep. I have a quick question regarding there are some websites where we can see that, we can do the wills online. I'm just going through a couple of them, like Legal Wills or Law Report. All they just say is you just need to have 2 witnesses, and then we have the lawyers review our document, whatever you're filling online, and and it is valid for n number of changes that you wanted to do, and it is it is finally. So how does it get authenticated? Like, if these online documents, how does it say that it is authenticated document and anybody can be executed and anybody can follow it? That's one question. And second is like, um, is like, do we need to share the wills with the executors, because how they will know about what my details that I put in the will?
Okay, so I'll be able to answer both questions. So first question, dealing with how do you authenticate a will that you have, or ensure that a will that has been drafted using a wills kit is done properly. I've read a few of those wills kits. Some of them are good, some of them are not so good. The main issue with those will kits and ensuring that they are done properly is that when you prepare a will, you have to use very, very specific terminology, and it has to be drafted in a very, very specific way. And while those kits tend to give you all of the basis for putting together a proper will, they don't really give a lot of instruction. So can you put together a will and bring it to a lawyer to review? Absolutely. You may not like the response that the lawyer gives you when he or she says, this section of the will needs to be redrafted because it doesn't properly reflect what your wishes are. So if you are going to go that route, having it reviewed by a lawyer, absolutely, because I have read many handmade wills or wills done with online kits, and of all of those that I've read, I've seen one that has been done properly. The rest of them always had issues. Now, with respect to the witnessing of those wills, again, if you're going to witness the will electronically, one of those witnesses has to be a lawyer. Otherwise, the only way to have a will properly witnessed to ensure that it is valid, it must be done in person, which with the social distancing mandates that we have right now may be difficult. I mean, you could get a couple neighbors together and they could stand outside and watch but maybe they won't feel comfortable about that. So there are very, very specific rules when it comes to ensuring that a will has been executed properly. If any of those rules have not been followed, you have an invalid will. Now, the second question of should we tell the executor what's in the will so that they understand what our wishes are? That really depends. Number one, first and foremost, you should always ensure that if who you appoint as an executor, that you have had a discussion with them beforehand to ensure that they feel comfortable acting as an executor. You cannot force somebody to act as an executor. You can write them in your will, but you cannot force them. You cannot force them to act. So you need to make sure that who you name is comfortable. Whether you decide to share with that executor what's in your will, that's up to you. Do they absolutely need to know what's in it? No, they don't. Would it help? Possibly. What the executor needs to know, however, is where your will is located, because there's only one original will ever signed, and your executor needs to put their hand, needs to be able to find it in order to be able to act on it. Acting on a copy of a will is possible, sometimes very difficult to go that route. So your executor needs to know where your documents are. So hopefully I've answered both of the questions there.
Yeah, thanks, Keith. And executors are liable for legally liable for any debts or liabilities that we have after we pass away.
So in Canada, the debts of somebody who's passed away are the responsibility of the estate. You cannot pass along your debts to your beneficiaries. This is actually different. In some places in Europe, you can actually pass along your debts. That's not the case in Canada. So are your executors personally liable for your debts? No, they're not personally liable. However, their responsibility is to ensure that those debts are paid. So if the executor does not properly pay out the debts and decide, you know what, I'm not going to pay CRA, I'm not going to pay them the credit card companies off, and I'm just going to hand over all the money to the beneficiaries, then the executor can be held personally liable for failing to act in their duty to ensure that all creditors are paid off. So are the liabilities automatically passed to the executor or beneficiaries? No, they're not. But if an executor acts inappropriately and does not pay the CRA or creditors, then yes, the CRA creditors can go after the executor personally for that.
Say any of the executors can do any of these, right? Like it's not one person, it's any of the executors do get the thing. Like, I mean, it's confusing because when you say they're not legally liable, but CRE and other people can come after. It's like, a bit confusing to say that it looks like they're liable.
Mm-hmm. So I mean, that question, it depends on what the executor is doing. And again, it's a question, are you naming one executor? Are you naming multiple executors? And it's going to boil down to, what do they do? Do they take your assets, pay your creditors off first, and then hand over everything to the beneficiaries? That's the right way to administer an estate. Or do they just hand everything over to the beneficiaries and say, you guys deal with it? That's the wrong way to deal with administering a estate. And in that situation, they could be personally liable. Whoever your executor is, whether it's individual or multiple individuals, they could be personally liable to repaying what those debts are.
Thank you, Keith. We'll move to the next question. We have a couple of questions from Rama, who's been posting the questions in the chat. You want to go through that? Or Ms. Rama, you can ask the question here too. So the first question that was put forward was, can an executor be a beneficiary to the will? And should the executor be a resident Canadian?
The answer to the first question is yes. An executor can be a beneficiary of a will. The answer to the second question is, should they be a resident of Canada? It depends. Can they be a non-resident? Yes. You can name an executor who has a residency anywhere else in the world, but it forms some practical limitations. If your executor is not present in Canada, then having them administer an estate in a different country, there's going to be some difficulty with them coming over to Canada, making sure that taking control of the assets, and then flying out and trying to deal with everything remotely. So is it impossible? No, it's not impossible. I have executors all over the world. I've got a guy in Italy right now, and we're having no problem whatsoever. Again, the question is, who do you trust? If you don't trust anybody in Canada, and you have somebody who you'd like to name outside of the country, can you do it? Absolutely. The real question is, should you do it? Because there will be some practical limitations. The other limitations that will potentially come into effect is, where a non-resident is an executor, sometimes, not always, but sometimes courts will require that executor post a security bond with them in an amount equal to the value of the estate. So let's say the estate is worth $1 million. The executor is from a different country, Italy, for example. The court may say, you know what, we want to make sure that the beneficiaries are protected. You need to post a security bond with us for $1 million, so that if you steal the money and fly out of the country, there is still funds available to the beneficiary. So again, that would need to be taken into consideration before naming an executor who is a non-resident. But yes, they can be beneficiary to the will.
Oh, hi, Keith. I have a question related to the same thing. Did you say that a beneficiary cannot be an executor?
Sorry, a beneficiary can be an executor.
Oh, okay.
Yeah.
Thank you.
The only time where a beneficiary or where an executor should not be appointed, or sorry, the only time where a beneficiary should not be as an executor is where you are trying to establish a trust. So what that means is that if you have a child who is under the age of 18, or you do not want that child to receive their inheritance until a specific age, you cannot name them as the executor. So number one, if they're under the age of 18, they can't act. And number two, if you don't want your child to receive the inheritance until the age of 25, you cannot say, I'm naming my child as the executor, but they're not allowed to use that money until the age of 25. That doesn't work. They won't be rejected as an executor. They can still act, but in that situation, they will not have to, they can't hold money in trust for themselves. So they'll just have access to the fund. So that's really the only situation where you should not name a beneficiary as an executor, but any other time it's fine.
Okay. I also remember you mentioned about a will and a living will. Are they separate or are they the same?
So those are separate documents. So a will is a document that deals with the distribution of your assets after you've passed away. A living will, we don't actually have living wills anymore. It's a term that's still used. A living will is in actual fact a power of attorney for personal care. And it's and that document deals with appointing the individual or individuals who is going to be responsible for making all medical or personal care related decisions on your behalf while you are alive. So we used to have living wills. That was about 30 years ago, and then the legislation changed. And now we no longer have living wills. We have powers of attorney for personal care.
Thank you.
Keith, can we have multiple executors? And if so, if you have multiple executors, how would they be acting? Like, do they go by the majority, or can anyone act among those executors?
Yes, you can have multiple executors. If you have an odd number of executors, so if you have 3 executors or 5 executors, don't have that. Just don't do it. It'll cause too much of a problem. But if you have an odd number of executor, yes, you can. You can have a majority rules, or I guess 4. You could vote 3 of the 4. So yes, you can have a majority rules clause, but that would need to be specifically inserted into the will. Otherwise, if you have co-executors, if you have more than one person as an executor, then all of them need to agree on every single decision. They all need to work together, and they all need to be able to forge together.
Thank you, Keith. In the interest of time, we're going to ask the last 2 questions. The first one that we have is, do we require multiple wills to deal with business assets and personal assets separately?
So this question requires a very long and in-depth answer. The short answer is yes, you can have multiple wills to deal specifically with corporate assets. In that situation, we would put together what are referred to as primary and secondary wills. And what we're doing is we are separating the types of assets that you own into 2 categories: shares in a corporation and personal property, so possessions, things in your home, and everything else. And so we're putting the corporate assets and your personal possessions in the second will, and we're putting everything else in your first will. Can you do it this way? Yes, you can. Why do we do it this way? To minimize the payment of estate administration tax. Should you do it? Very different question. It boils down to whether it's cost effective, because the only reason for doing it this way is to try and save on the payment of estate administration tax.
Sorry, can I just jump in on that? It raises a slightly different nuance from our perspective. Again, as part of business succession planning, insurance does have a role there. And a very quick example, let's suppose Keith and I started, the estate planning company, and we're equal partners in this business. And, unfortunately, one day I passed away. and we're both equal shareholders. Now all of my assets get passed to my wife, and Keith's working one day trying to manage the business, and my wife walks in and sits down at my desk and says, "Okay, I'm the other new owner of this company, so what are we doing?" And without any of the expertise required, this puts Keith in a very difficult situation. So things like a buy-sell insurance could actually fund, because Keith wouldn't have, let's suppose Keith doesn't have the money to buy out my wife and take sole ownership of the company. Here's another way that we use insurance, that upon my passing, Keith as a beneficiary receives the estimated value of my interest, which he can use to basically pay out my wife and get her her value of the business, and Keith can carry on the business in a fashion that is appropriate. So again, it's a slightly different nuance, but again, there is a role that insurance can play in the event of business succession.
Thank you, Akshay. That's a very good point, because that's a very common issue for estate planning for individuals who own businesses and have partners, and it's one that's typically overlooked.
Sure, Keith. And the last one for today is, can the executor refuse the responsibility at the time of execution?
Yes. The short answer is absolutely. You cannot force somebody who's been named as an executor to act. However, they have to refuse right away. If they start doing some work and a month or two in, they say, you know what, this is way too much work, I don't want to deal with it, the only way that they can at that point step down is through a court order. That's the only way. Otherwise, they're going to be held personally responsible for failing to act in their duty, which is why it's very important to make sure that who you name as an executor, that they agree to do this, because even if they say yes now, at the time that somebody passes away, they can still refuse, even if they're named in the will.
Keith, I have a question on that. So if the executor has denied at that point of time, and there's only one executor on the will, so who would take the control of the will, like as an executor?
Mm-hmm. So at that point, it would the beneficiaries of the will, if there's no named executor, if they've refused or the executor's passed away and the will was never updated, then the beneficiaries, the majority of them, 51%, have the ability to vote and appoint a new executor. And however, the process for appointing that new executor requires that new executor apply to the court and have themselves appointed formally through the court. And to complicate things even more, if you have minor children, so children under the age of 18 as beneficiaries, and the executors refuse to act and there's only one of them or they passed away, then all of a sudden you need the representatives of those minor children, who are either going to be those children's legal guardians, or if there's no legal guardians, then the office of the children's lawyer to get involved. And then at that point, it can get very, very messy. So making sure that who you named and revisiting that, you don't have to do it every year, but every few years, just to make sure that you're still in contact with who's the executor and that they still agree to do that. It's very important, because without an executor, it can get very complicated.
Thanks, Keith.
Yeah.
I have a question on the offshore executor. I understand that you answered over the executor abroad. Can there be a beneficiary offshore, like on another country?
Absolutely, yes. Depending on what the country is and depending on what international treaties Canada has entered into, that beneficiary may be subject to some form of estate tax before they can receive their inheritance. I know this to be the case for certain beneficiaries who are living in the United States. There is a form of estate inheritance tax that they have to pay before they can receive their inheritance. At that point, you're going to need a tax advisor to really give you the proper answers to whether and what are the tax consequences. But the short answer is yes, you can name a beneficiary who is not a resident of Canada.
Hi, Keith. I have one question. When we do a will, and after that we want to do an amendment at the later stages, again we have to go through the same process, like the initially how we went to the lawyer, like to do everything. Then again for amendment, also same procedure we have to follow, or is there any simplified procedure will be there for the amendments?
So that's going to depend on the extent of the amendment that you want to make. There's two ways that you can amend a will. Number one, you can do a brand new will, which is generally recommended if you are changing who the beneficiaries are. If you're changing who you're leaving your assets to, you need to make a new will. Smaller changes, such as changing of executors or changing of guardians of children or ages and things like that, you can use what's called a codicil. Codicil is a short, it's usually 1 or 2 pages long. It's a short amendment. It's attached to your existing will. The process for that is a lot shorter, a lot quicker, and a lot cheaper. So do you have to go through the exact same process to change a will? It really depends on what changes you're going to make, but if the changes are simple, no, it's a fairly simple and quick process.
Okay, just one added question on to that one. Is all assets needs to be listed in the will where we are making, because say we are in the, still acquiring the assets are all as and when we added more assets, so if we need to list out all the assets, or we can just say okay, so all the liquid assets or physical assets kind of thing.
Mm-hmm. So do you need to list out all your assets? No, you don't. There are 2 types of gifts that you can make under a will. You can make what's referred to as a specific gift. You can make what's referred to as a general gift. A specific gift is just that. I am specifically gifting you this chair. I am specifically gifting you this bank account and all of the money in the bank account. In those instances, you do need to list out the specific asset, or you could say I'm specifically giving a certain sum of money. A general gift refers to a percentage of your estate. So everything lumped together. And in that situation, you do not need to list all of your assets. So as you accumulate, acquire more assets, you don't need to update your will unless you've acquired something now that you want to leave to a certain individual.
Okay, thank you so much, Keith.
One quick question. If the executor is passed away by the time will come into effect, what would happen? Same rules like beneficiary with 51% will become the immediate executor? Keith, can you please clarify?
It would be the same rule. So just to clarify on that, the beneficiaries wouldn't become the executor. They would have the ability to vote and confirm who the new executor is.
Thank you, Keith, and thank you, Akshay. It was a wonderful presentation today, and we really have learned a lot. Given that we are all first generation, second generation people here in Canada and settling in, the laws of the land are something that we are all learning today, and you have really put some light on how we should be planning for our estates, as well as making sure that our loved ones are cared for with some insurance that we take for our life, and both for term as well as the other options. Unless we have any other question, I think
we just urge 2 things, if I can just jump in at the end here. So 1, start planning now. The best time to prepare for a rainy day is when it's sunny. Because when there's a hurricane, that's not the time you want to be out boarding up your windows and dealing with things in an emergency situation. So start planning now. And the second thing is just ask questions. I love all the questions that were asked. And I would, as you advance through your plans, continue to ask lots and lots of questions. Because again, as I said off the top, I believe in education and making informed decisions. And you don't want to be in a situation where you don't have an effective plan because you felt embarrassed to ask a question. So there's no such thing as too many questions, and there's no such thing as silly questions. So, get the guidance and take the right steps to protect your family. That was the 2 things I have to add. Thank you.
Thank you, Akshay. Gentlemen, have a wonderful rest of your Sunday and take very good care of yourself. And we'll come back to you with some more information on estate planning and wealth management in the coming days. Good day, folks.
Thank
Thank you very much, everyone.
Thanks, everyone.
Thank you.
Thanks, Murli, for organizing it. Yeah, thank you. Bye.
Thanks, Keith and Akshay, for your time. It was wonderful presentation.
Yeah, you're very welcome. Sir.
These topics are very sensitive, and everyone is not going to take it so personally, but you guys walked us through with all the sensitive information. It was awesome, and with real, real examples, real-time examples. Those are awesome. And I think as next steps, Murli, so we can probably share the details of Akshay and Keith. So if anyone has follow-up questions, we can reach out to them.
Sure, Kiran. I'm going to call you offline after this call, and probably Keith and Akshay. I'm going to call you, let's say, talk tomorrow or so, and we'll discuss further steps.
Yeah, okay. I think team has questions around the price tags as well. Looks like so that's another sensitive topic.
Yeah,
but I think we have to work it out. We have to see what can be done to get a better price. Yeah, I think thanks everyone.
Yeah, so we are going to connect with you, and we will take this offline.
Super. Thanks everyone.
Thank you so much.